So we have United engaged in this district-wide service of protecting the groundwater. And along comes the city, and not just the city, a number of pumpers. They're well operators. They make their own facilities, they make their own choices, they're required to register. They may not pump unless they register. They may not pump unless they pay the pumping charge. They are receiving that benefit, the benefit of being able to pump. And when they do pump, there's going to be groundwater for them. And that groundwater is going to be present. It's going to be of a quality that United protects, preserves, conserves, augments.
What about the fair, reasonable relationship requirement?
Very good. Our Court of Appeal thought, and I agree with them, that Sinclair Paint and California Farm Bureau tell us how to look at the fair and reasonable relationship requirement. And our Court of Appeal gave it perhaps shorter shrift than this court would like. They said, if you're charging someone for a benefit or for their burden based on the volume that they draw, such that someone who draws more pays far more than someone who draws less, like perhaps that domestic user that you're concerned about, this is fair and this is reasonable. Now, you've let us know, you've signaled to us, thank you, Associate Justice Cuellar, in the Jack's decision of earlier this summer, that Sinclair Paint's reasoning, both on the reasonable costs and on the framework for proportionality, that it be fair and reasonable. And there are other cases earlier that look at this and talk about informed decision-making by the elected officials. Informed, honest, fair, reasonable. These all characterize the activities of United Water, and I don't know if I have any time remaining.
I'm still not clear on one basic issue, which is what Justice Kruger started with, which is what is the difference between this requirement and the Prop 218 requirement?
Prop 218, I've read it and reread it, and I can't see it saying anything other than the cost has to be proportional to the cost of service on a parcel-by-parcel basis. That's what it says. And the fact that the Pajaro line of cases has construed that differently is discomforting to me. I like my constitutional interpretation to be based on what the constitutional mandate actually says. What does it say? So we try parcel by parcel, and Your Honors, if you hold United to that standard, they will meet it, but it will require some creativity on the part of all of the groundwater management agencies. There is a common pool here. There are 8 basins that United protects. Despite what you heard this morning, the trial court held that there was a common pool. And that means that we can't trace a molecule of water in the groundwater the way we can trace it in a pipeline. Why? Because water flows in complicated ways, ever-changing ways. And the scientists and hydrologists and biologists who work at United are constantly challenged to understand the best recharge methods because of the complex hydrology. Pumping in one area, ultimately, and United's mission is a penultimate mission, it's to protect the groundwater into the future. United cannot do that molecular tracing. I think of groundwater like a bad house guest who moves from room to room when you're not watching. And that is how groundwater operates. That's how groundwater works. And that's why, Justice Liu, it is such a challenge mentally for me to understand how groundwater management, conservation districts like United can do a parcel-by-parcel allocation. They'll do it if you require it of them. They have tried over the years to do that very thing. But when I look at Prop 26 and E1, I say, Eureka, we are found. There it is. That is what's happening here. United is providing a district-wide service, Prop 218 tells us a district-wide service, you can't do that. You can't, there can be no free riders.
So Ms. Escher, your
Yes.
time's expired.
I'm so sorry, but thank you for your attention.
Let me try again to answer Justice Kruger's question. What difference does this analysis make? The 218 test looks to the cost to serve a parcel or a class of parcels. So what services are they getting? What costs do we incur? 26 asks us whether there's a fair or reasonable relationship, lovely lawyerly or fair or not reasonable and reasonable and not fair, relationship between benefits and burdens. The benefit is typically going to be the service itself in a service context, but 26 applies in non-service contexts. It applies in regulatory contexts. So I don't think that the benefits and burden analysis will very often differ from what are we giving you and what does it cost to give it to you. But in some cases, it may. As I try to conceive of a case that would come out differently, this occurs to me. The third exception in 26 is for regulatory fees that recover the cost of regulation. And it was obviously written in light of the San Diego Gas and Electric case, where your permit fee was based on your volume of emissions. I can conceive of a case in which you're charging you for regulation and provide you no service, because we never interact with you, because you never come to our attention as a violator, so we don't address you. So you're not putting any burden on us, so there's no fair relationship to burden, but there is benefit. Because you're in an even marketplace, your competitors are not getting an unfair advantage by not complying with rules that you can comply with. So I think the regulatory example might give us a framework to think about when it might matter. But I think primarily it's just a different thought process that is frequently going to arrive at similar results.
But so your friends on the side say that the primary difference is that 218 requires this allocation be done parcel by parcel. I assume you...
And that is an important difference, but it ends up being practically not very different, because class by class reasoning is necessary to make sense of all of this data.
But the generality of the class and how it's drawn matters greatly.
Sure does.
To the rate-making process.
It sure does. The other point about 26 is that the gateway into this analysis differs. 218 applies to fees on the tax roll and otherwise directly on property, and for certain property-related services. 26 applies to everything, but once you're applying one of the exceptions in 26, there are standards to be met. So here they needed to show direct benefit. They needed to show reasonable cost. They needed to show free riders.
And what's missing?
They didn't try to meet this test. They said, we provide broad social benefit, and therefore we can't show you any direct service to anybody, and we can't disprove free riders because we're doing health and safety in the environment. They didn't try to prove compliance. They tried to fuzz up the test to the point that anything would pass it.
The term cost is used in both Prop 26 and Prop 218. Do I gather, as I try to process how you've set this out, that you think the term cost in both means essentially the same thing, or it means something different?
I think cost has both an ordinary meaning and a more specific meaning. And the more specific meaning is there are folks who are in the business of cost accounting for government, and they have very sophisticated understandings of how to do cost allocations. And in this record, we make reference to the American Water Works Association's M1 manual, which Griffith said is a good way to do rate making. There are similar ones out there. But cost accounting, there's a lot of people who make a living under that job title. So there is known science here. It's like anything else. It's not going to give you just one answer. This is legislative activity. There's a range of reasonable rates to be made here. They want you to believe they can't account for their costs, but they created Zone B. If they can't account for different costs, why did they create Zone B? It's not all one pool in their own view.
So what I hear you saying is, to the extent that there is any flexibility in how that term cost is defined, it still requires cost accounting and it requires a record.
Because a record, because reasonable legislative judgment informed by a record. Now, I want to return, if I can.
Your time's expired.
Okay. Thank you.
30 seconds.
Okay, 30 seconds. Your question about why I should persuade you that the statute is unconstitutional. There are flatly inconsistent duties in the Constitution to account for costs and in the statute to ignore them. The Constitution says, notwithstanding any other provision of law, so the preemption here is not implied, it's express. And lastly, you've got a long line of cases showing the breadth of preemption that 13 and 218 do, Ventura Group and Manteca among them. Thank you.
Thank you, counsel. Matter submitted. calling the matter of Alexander Vasilenko versus Grace Family Church. The Honorable Barbara J.R. Jones, Presiding Justice of the Court of Appeal, First Appellate District, Division 5, sitting assigned. Have a seat, counsel, and when you're ready, you may proceed.
Thank you, Madam Chief Justice. May it please the Court, my name is Paul Delormier, and I represent the defendant and respondent, Grace Family Church. Premises liability is predicated upon the concept that possession includes the attendant right to manage and control the premises, justifying liability when one has failed to exercise due care in the management of their property. Those are the words of Justice Ray in his dissent in the Vasilenko matter. They're also from Sieber versus Hotel del Coronado. Now, this is a duty of care case, and we have here the concept in this duty of care that possession and the attendant right to manage and control property triggers the duty only when the holder fails to meet that duty of care in the management of their property. This is a basic tort concept which the Court of Appeal in the Vasilenko decision missed the ball. The Court of Appeal decision must be overruled. It is not only violates this very basic concept, but it is unworkable. We start with the Rowland factors and Civil Code 1714. We understand that everyone is responsible for an injury occasioned to another by his or her want of ordinary care or skill in the management of his or her property. But we have various exceptions which have been clearly supported in law and restated by this court on multiple occasions that a defendant cannot be held liable for a defective or dangerous condition of property which it does not own, possess, or control. That's from Isaacs versus Huntington Memorial Hospital, restated again in Alcaraz versus Beachy, restated again by this court in Carson versus Facilities Development Company. And we go back to the words of Justice Mosk in his famous dissent in Connors versus Great Western Savings and Loan, that the right of supervision and control goes to the very heart of ascribing tortious liability. Now, there's exceptions to this rule.
Counsel, we have these cases, you know, that impose or find a duty where a mobile business has located in a particular location.
Yes.
And impose a duty because of that location. So just talk through how you distinguish those kinds of cases in that line of reasoning.
Well, those kinds of cases, the Schwartz versus Helms Bakery is the main case in that regard. We have a situation here where a vendor is selling on the street. The zone of area where that vendor is selling is the area around his truck or around his or her truck. And that is the zone of area that is going to be where the duty is going to arise. When you create, as the Court of Appeal did in Vasilenko, a situation where the condition, we have the church's property, which is abuts a major street, a busy street. We have occasional use of an exterior parking lot, which is also on a busy street. There is nothing of a condition of those premises which cause anything more dangerous on the city street.
When you talk about the zone around a mobile vendor, is that a matter of distance that you think distinguishes the church here, or is it something else?
No, I don't think it can be. It can't be equated with the church, because when the cases of Steinmetz and Navarez and then Owens limited this type of area where you find a traveling business, a traveling vendor, to the situation where it travels because they have control over where they're going to park their truck and sell their goods. This has never been applied to a premises holder who has an area of fixed location where their business works at a fixed location. primarily because it's an unworkable way to equate the duty of care. I think
But doesn't the church have some comparable authority over where it locates its overflow parking?
well, I think that's a very good question, but the issue there is the church is only going to be able to use a parking area which is available to it. It doesn't really have an ability to pick where it's going to have its parking lot. It's not, the Court of Appeal in Vasilenko made it sound like they could pick and choose where they were going to put their parking lot. That's not going to be the case. And even in a situation of an urban property owner, a downtown property owner, for instance, who contracts with other off-site parking to provide parking for people that come to their business, it would be a very onerous burden to try to figure out a relative safety system whether someone has to cross a busy street. I think it's very important to realize crossing a busy street is not an unreasonable risk of harm. I think in our collective lives, we've crossed busy streets thousands and thousands of times. It happens all the time. It happens every day. Courts in this state, superior courts, courts of appeal, have on their websites where you park your car when you come to visit the court. Oftentimes, those parking lots are not contiguous with the court. People have to cross a public street. They have to cross busy public streets if it's in an urban area. To say that's an unreasonable risk of harm, and to say whether or not a property owner needs to decide, well, whether one has a crosswalk or a signal, the duty has to end when there's no condition on their property creating the issue, creating the negligence occurrence. For instance, in Barnes, we have a property that has a driveway, a steep driveway, a child play area, and a sidewalk. A child is playing there and is catapulted into the street. It was the condition of the premises that resulted in that duty of care.
So you would have us draw the distinction categorically at the line of the owned property of the entity? So what if the church had, 300 regular attendees and 3 parking spaces?
At their own site.
Yeah.
Well, I think that happens often. I think there's churches that have that.
There might be a disparity between attendees and parking spaces, but maybe not so often between 3 parking spaces and 300 attendees.
I understand.
The point simply being, can you imagine at all a situation where maybe the tort-related inquiry would require us to look at the facts and not have as much of a categorical rule saying simply because the particular conduct in question happened beyond the property line, it's simply beyond the purview of our analysis?
Well, I think we have to look at this in terms of a category of negligent conduct. And in the Inoki case, it was a condition, this is a restaurant next to a busy street, and the court found that it was the condition of the driveway on the premises that resulted in confusion to people driving out of the parking lot. But it was a condition of the premises. I think if you get beyond that and you get off the premises, the duty, no case has ever found anything like that for a premises liability, in a premises liability setting.
In this case, did the church increase the likelihood that at least to some extent that church members would encounter harm by crossing the street after parking in the adjacent lot?
No, Your Honor, I don't think so. I think the Court of Appeal in Vasilenko made the mistake of finding that because the parking lot was not next to a crosswalk, that somehow that resulted in an unreasonable risk of harm. But that is not an issue that should be determinative of this issue, because crossing a major busy street is not an unreasonable risk of harm. And have I answered your question?
Yes.
I think further on in reviewing the rules set forth in Rowland, I think in the issue as far as foreseeability goes, we have to think in terms of a category of negligent conduct. In Rowland, the premises holder, it involved a broken faucet handle, which was known to be broken by the property owner, was not readily apparent to a visitor. It's a condition of the premises. In Anoki, once again, I believe that the court found it was a condition of the premises because it was a confusing driveway. In Barnes versus Black, again, it was this driveway that catapulted a child into the street. In Bigby versus Pacific Telephone, when we used to have telephone booths, this was a telephone booth that was difficult to open and resulted in a duty of care to the company, to the phone company, because it was their property that created this duty, this unreasonable risk. In McDaniel versus Sunset Manor, we have a condition where the apartment has multiple children. Next door to that apartment is a creek containing a 7 to 8 foot vertical drop, and all that separates between the children and the creek is an old dilapidated fence with a hole in it large enough for a man to get through. All of these cases involve a condition of the premises. Then you have, similar to McDaniel, Brooks versus Eugene Berger Management, another apartment house where a child runs out into a street. All we have here is an apartment building next to a busy street, and the court found there was no duty to put up a fence or a wall to prevent the children, even though premises owners knew there were children present. In Donald versus California Western School of Law, we have a situation where the school knew there was a dangerous criminal activity off the site. But in that case, the school was not held to a duty. They did not provide on-site parking. They knew that the students would have to leave the school and go out into this area of criminal activity. But the court found no duty in that situation. All of these cases require, for a duty to be found, that there has to be a condition on the premises triggering this duty of care. I think that one of the issues that is raised by my colleagues is the control argument, where the Court of Appeal spoke to the issue that somehow the church was in control of the area off the site from the parking lot. This is a very seductive argument. The church did not own this lot. The church did not have any type of formal rental agreement for this lot. The church had temporary use of this lot as a parking lot, as an overflow parking lot. And during this temporary use, the plaintiff was injured because he crossed the street during the conditions that occurred. However, in an urban setting, having an off-site parking lot is not an unreasonable risk. And unlike Schwartz versus Helms Bakery, which involves a traveling street vendor, this is not a situation where the church can move the parking lot from one area to another. Another case that the court deals with below is Bonanno. In that court, the court actually came to the realization that in Bonanno, that case, which involved a question of a dangerous condition of public property, whether the location of a bus stop was a dangerous condition. And in that situation, we have the court stating that they were more like Schwartz versus Helms, and it involved a situation where the bus district could move the bus stop. Moving the parking lot is not something that's readily available to the church. And the other issue I think that's important about Bonanno, because the Court of Appeal relied on it to such a great degree, our case is a duty of care case. And the Bonanno case involves a condition of public property based upon the statute. The analysis of whether something breaches a duty of care is not the same as one whether a dangerous condition of public property exists. And I think that Justice Werdiger, in her decision in Bonanno at footnote 4, makes it clear that the analysis of a dangerous condition of public property is not the same analysis. And she states there, the principle at work is not that property owners must ensure the safety of all persons who encounter nearby traffic-related hazards in reaching their property. That was the condition that Justice Baxter discussed in his dissent. But that public entities are subject to potential liability not as insurers, but for their own negligence, and not as a matter of common law, but by mandate of Section 830 and 835 of the Government Code, when their facilities are located in physical situations that unnecessarily increase the danger to those who, exercising due care themselves, use the facilities in a reasonably foreseeable manner. The indication being the analysis of a duty of care of a premises liability case is not the same as whether or not someone has violated the Government Code.
I noticed on the map in the record that there is apparently a church parking lot.
Yes.
Catty-corner from the church, across route.
It's I believe that it is it's a lot. It's another private lot owned by another commercial lot, which the church.
Not owned by the church.
Not owned by the church.
Mr. Laurie Millet, your time's expired.
Thank you.
My name is Eric Borston from Horvitz & Levy for Defense Amici. And I have a couple of points to make to start out with, and I also wanted to address a couple of the court's questions. One point I wanted to make is that California should not become an outlier when it comes to recognizing duties to protect against dangers off of a premises owner's land that premises owner did not create or control. And I know the briefing cited a lot of out-of-state cases that went to this. And I just wanted to emphasize that it really is the minority view that a duty could exist here. And it's a minority of one, just the Warrington case out of New Jersey that my colleagues on the other side cited. Warrington is an interesting case. There was held to be a duty for a restaurant to provide safe passage across the street to its parking lot. The interesting thing about Warrington is that it was a direct result of a 1981 New Jersey Supreme Court case that held that there was a duty for a business owner to repair a sidewalk that abutted the business owner's premises. That's the opposite of what the law is in California, as recognized in Sexton 65 years ago, which cited Martinovich, which was from 1900, which then cited the common law, which pre-existed that. So for over 100 years in California, the rule is a business owner does not have a duty to remedy a danger, even abutting his property, that the business owner did not create or control. And that's the rule that businesses in California have structured their expectations around. That's what they've set their prices based on. That's what they've structured their conduct based on. That's what governments have structured their conduct based on. I don't hear plaintiffs in this case asking for a departure from that rule. But a departure from that rule is the only thing that gets you to liability in this case. That's why the New Jersey court said that there was a duty to ensure safe passage to a restaurant's parking lot based on that New Jersey Supreme Court case that is opposite from California law. On the other side, the side that California should choose to continue to be on, you get Davis out of Massachusetts, Ferreira out of Rhode Island. You have those are the highest court cases there. Then you have the intermediate appellate court cases in Illinois, the Sweat case, North Carolina, Lauman. You have New York, Ovechina, and you have Georgia, Walton. All of these cases recognize that there's no duty to ensure safe passage across public street, even if the property owner somehow influences people to access its property through a certain way.
How do you distinguish the Bonanno case?
So the Bonanno case, I think, was an application of the Schwartz case that Cuellar was alluding to before. The city or the bus authority really could locate that bus stop anywhere. It was akin to a mobile business. You could put one place, you could put another place. You're not linked to a premises that's in one place that's owned or controlled by a landowner. And if you look at Schwartz and how courts have applied Schwartz, going back to your question, it really is cabined to the situation where a business is mobile. So a truck can go anywhere. So if you look at Navarez, Owen, Steinmetz, Sieber, Donnell, in all of those cases, there's some amount of control exercised by the defendant over the possible means of ingress or egress to the property. So in Steinmetz, they held a business mixer in a dangerous area of town. Well, Steinmetz could have picked a different industrial park to hold the business mixer. That doesn't make it a mobile venue subject to the Schwartz line of cases. In Sieber versus Hotel del Coronado, you had an entrance, but maybe the hotel could have closed that entrance or opened a new entrance or warned or put signs directing people not to use that entrance next to the dangerous crosswalk. Something that might escape attention a little bit is in Donnell versus Cal Western, the plaintiff actually parked on a faculty parking lot owned by the defendant, Cal Western. So you have a very similar situation to here, or even, I guess, more of a connection to the defendant, because the plaintiff parked on a parking lot owned by the defendant, crossed public land to then get to the other property owned by the defendant. Now, it really wasn't an issue, the fact that faculty lot was owned by the defendant, because for whatever reason it didn't come up in the decision, but those facts are not reconcilable with holding liability here.
So would it be appropriate for a court to, in deciding the existence of a duty of care, to look into the other options that might have been available for parking that might not have required crossing busy streets? So if the record showed that there were 3 other available parking lots on the same side of the street within a 3-block radius, is that relevant to the inquiry?
Your Honor, I think at the level of generality required by Cabral, it is not relevant. Anytime a business chooses a parking lot, you can imagine that there's some parking lot twice as far away that maybe has a slightly different safety characteristics for approach. So if you don't want to impose a duty on a business owner to, you can choose the lot across the street against that's across a busier street versus a lot 3 blocks away that requires you to hop over 3 unremediated cracks on the sidewalk and is dangerous from that direction. Or that a certain group of people hangs out south of the business and they don't hang out north of the business, so you shouldn't choose a parking lot south of the business.
I gather, counsel, your point is that there's some value in discretion and not micromanaging the choices of the entities that are being regulated by tort law. But in Kessner, we reaffirmed something very familiar in tort law, which is that the core premise of tort law is that we ought to look for those parties that are best situated to prevent injuries and incentivize them to do so. How is that purpose served by a categorical finding of no duty here?
Your Honor, the person best situated to avoid this injury is the pedestrian. That's the person that knows how fast he or she can move. That's the person that can assess the visibility. That's the person that can assess the traffic flow at any given situation. I know in this case it was alleged that the fact that it was raining made a difference, the fact that it was night made a difference. To put that burden on the business owner to choose a parking lot that works in all sorts of different situations for any type of foreseeable pedestrian is, I think, an unworkable burden. People are used to crossing streets. People are used to assessing traffic. People are used to deciding for themselves what level of risk.
Sure, but let me here channel a version of Justice Kruger's question. Let's suppose that I agree with you that that's true in the typical busy street scenario, the typical parking lot situation, the pedestrian, the driver, better positioned to prevent harm. But might not there be some streets, exceptionally dangerous streets, specific circumstances where that would not hold?
Your Honor, I could see as a factual matter, yes, there might be some factual circumstances where that would hold. I don't think that affects the analysis here. Cabral requires that we analyze the decision whether to create a categorical exception to the duty rule at a relatively broad level of generality. And that presumes that there might be some factual cases where if you were really looking at the individual facts of every case, you might think it's more fair to have liability, and the categorical rule says no liability, and the converse might also be true.
I think that Cabral is important, but it does sound to me like a core part of your argument here turns on that word relatively broad, relatively general, and just determining exactly how broad or general it should be in this particular circumstance.
I agree that determining how broad or general it should be in this particular circumstance is a very key question, and I just urge the court to follow the part of Cabral that says you look at it at a relatively broad degree of generality, and if the rule is, you know, in circumstances where it benefits the plaintiffs to pick out every single, you know, unique fact to the case, that's just as irrelevant as the situations where it benefits the defendant to pick out the unique circumstances about how this particular injury wasn't foreseeable, and that just the Cabral rule be applied consistently and try to achieve a uniform level of generality no matter who might stand to benefit.
As a follow-up to Justice Kruger's question about the 3 parking lots adjacent to the church, I questioned your co-counsel about the parking lot that's catty-corner from the church. It's very small, but it looks like it says parking for senior pastor and church administrator. Is that an alternative parking for church parishioners?
Your Honor, I don't recall anywhere in the briefing any side urging that particular tiny parking lot to be relevant to this case.
I know on the map that there's a street in the rear of the church that says no parking on the streets. Is there parking on Marconi on the street?
Your Honor, I don't know the answer to that question.
My question would be, if the plaintiff parked on the street on Marconi and crossed the street and was injured, would it make any difference?
Your Honor, it shouldn't make a difference. If the plaintiff chooses to park on the street on the other side of Marconi, the plaintiff would have to cross the street. It shouldn't matter that plaintiff parked in a parking lot that was controlled by the church. The fact that the church controlled the lot did not increase the risk to plaintiff one iota. I know that the line plaintiff wants to draw in this case to prevent this from being an amorphous duty that just expands without limit is they say it only applies when the defendant controls the parking lot. Well, that control didn't have anything to do with plaintiff's risk. Crossing Marconi would have been just as safe or not safe no matter who controlled the parking lot. So that's why I think it follows, just as there's no duty to assure safe access for someone who chooses to park across the street on the street, there's no duty that's created by this fact of control, where the fact of control didn't actually increase any risk.
Mr. Borstein, your time's expired.
Thank you, Your Honor.
May it please the court. The crucial point in this case is that this duty that the court is considering to use ordinary care to provide safe passage is not one that flows from any sort of obligation of the defendant to maintain the street or control the street or any other property that belongs to a third party. And the plaintiffs don't contend that the defendants have that burden. Instead, this duty flows from the defendant's obligation to use ordinary care in the management of its own property under Civil Code Section 1714A, because how a defendant manages its own property can unreasonably increase the risks to persons on adjacent properties.
When you say manage the property, that includes citing.
That includes where the location of the property, and in this case would include where it chose to establish an overflow parking lot despite its knowledge of the extreme danger of crossing from that lot to its premises and vice versa, and also in continuing to use that lot at certain times when it didn't have to use that lot. It had discretion to open or close that lot whenever it wanted to. And also in terms of location of its overflow parking, as discussed during the argument of opposing counsel, there was choice, there was control of the defendant in where to locate its overflow parking. It could be moved.
So, Mr. Toronto, I have to have a question with the focus of the parking, because I understand Mr. Vasilenko was hit in the street.
Correct.
And it's raining. So under my view is he parked his car and then he chose during this rainy night in the dark. He chose to cross when he chose to cross. He looked at the traffic, he made an assessment, he knew it was dark. I assume he's an adult, he's crossed streets before. What do we do with all of those other subjective factors that Mr. Vasilenko chose that caused him to be hit in the street that is not under the control of the church, nor did the church do anything to make the street more dangerous?
Well, clearly, comparative fault is something that the defense can argue at trial.
Well, I'm talking about it, I'm not talking about direct causation, I'm talking about the general abstract concept before we even get there of duty.
Okay.
And it appears, based on Mr. Borstein's arguments thus far, and the cases Mr. Laurier has cited, that we would be creating precedent here by finding duty as a matter of law under these circumstances. Well,
the court would not be creating precedent. In my view, the court would be applying its prior precedents to an extremely analogous factual situation.
What's your best case, counsel?
Our best case would be, Bonanno. The criticism of Bonanno has been that it's a public entity case, but if you look at the public entity theories in Bonanno, they are essentially identical to private liability theories. Under the Government Code Section 835, you have two ways that liability can arise on the part of a public entity, and one is if the public entity creates the dangerous condition, which means creates it in the first place, or increases a risk from a pre-existing condition, and that is completely consistent with private liability. The second one would be if the public entity is aware of a dangerous condition on its property and has a sufficient time to remedy the condition, but doesn't do so. And that's also exactly the same theory of liability.
What I've heard your friends on the other side say about Bonanno is something different, which is that Bonanno is more akin to cases involving, say, mobile food trucks or other kinds of highly mobile establishments where, there were a lot of choices on the part of the defendant in Bonanno as to where to site the bus shelter. Whereas here, if we're looking at things at a relatively high level of generality, there's no indication that a church with a fixed location or any similar establishment will have comparable range of choices about where to situate its parking lots.
Well, the church did have a range of choices, and any business has a range of choices. The church went out of its way to solicit the swim center to be able to use the swim center's parking lot. So the church made a decision to establish a parking lot at that location. They did so many years before this incident happened. During that time, prior to the incident, they were very aware of the extreme danger to its invitees of crossing back and forth from the church and that parking lot. Despite its knowledge of that extreme danger, it chose to continue to use that parking lot when it had no need to use that parking lot. The church's own map shows several different parking lots. It shows the main church parking lot, it shows the pool overflow parking lot, and then it shows, as one of the church's lots, this business plaza lot just down the street on the same side of Marconi, which the church has admitted had unlimited parking on the night of this incident. And yet, despite all those facts, they directed Mr. Vasilenko that you need to park at the
But I suppose if they had done that and Mr. Vasilenko were hit by a car on Root Avenue, you'd be here with the same claim.
We would not be here, Your Honor, because Root Avenue is a much safer street to cross than Marconi, and that is established by the
Unless you get hit while you're crossing it.
Excuse me?
Unless you get hit while you're crossing it.
Well,
So are you
it's
saying that?
either safer or less safe, and that doesn't mean you're not going to get hit.
Right, so what happens here is Mr. Vasilenko parks across the street. It's dark, it's raining, he chooses to jaywalk, he gets hit by somebody else. What exactly was the church supposed to do? To put a note in the bulletin saying, by the way, if you park across the street, don't jaywalk because you might get hit?
Number one, Your Honor, I would disagree that he was jaywalking. I think we've very clearly briefed this issue. The Sacramento County Code, this was not the city of Sacramento, the county of Sacramento, allows allows crossing at any point. It does not have to be at a street corner, as long as it's at a right angle.
Did he cross in the middle of the block?
He crossed in the middle of the block, which is a legal crossing because he went at a right angle.
But he crossed in the middle of the block?
Yes.
And he was hit by a motorist?
That is not jaywalking, Your Honor.
Thank you. He was hit by a motorist?
Correct.
So the first person who could have avoided this accident was Mr. Vasilenko?
No.
Who's the first person, the first entity?
Well, let's look at the situation. The defendant controlled the defendant's movements while he was off the defendant's premises. They told him where he must park at the pool lot.
I don't know that that's necessarily an accurate statement. You're saying that the church controlled where Mr. Vasilenko parked? Or was it merely directory, or you can park there, but controlled? Were they going to bar the church door if he parked over in the pastor's parking space?
They didn't literally, physically force him to go into that parking lot, but he pulled into their main parking lot.
That's
the
different.
attendant directed him, you need to park at this lot. There's no reason for him to reject that proposition. They also told him in this map, you must not park on the streets. So they have control of where he's going to park. This inhibited him from exercising his own discretion about where would be a safe place to park. It doesn't mean he's completely not responsible for any actions he's taken.
Counsel, you started your oral argument by telling us that you are not asking us to formulate a new rule. What is your response to your friend on the other side that says that it would be an outlier and only the New Jersey case supports you? And he outlined a number of other cases that are contrary. What is your response?
We briefed this issue very thoroughly in terms that there are dozens of cases that were cited by both sides. We, I think, very clearly distinguished all the cases that they are claiming are contrary to us, and we presented several cases that are on very similar facts to our case that did find a duty. And I know the court's not taking a straw poll. It's not how it's going to be done. But if you look at Donovan versus Jones out of Louisiana, the facts are virtually identical to those in this case. Lutheran Hospital versus Blazer out of Indiana is extremely similar to this case. Stevens versus Basha out of Arizona is extremely similar to this case. So to say that Warrington is the only case that supports a duty besides the 3rd District in Vasilenko is not correct.
Let me ask you, I mean, from some of this duty analysis is an evaluation of a variety of competing social policies, right?
Yes.
So it's balancing of factors. If there's a duty in this case, one can easily imagine that a church, and I don't know what kind of resources this particular church has, but just take the general case, is just not going to have the resources or expertise to conduct all the traffic studies, all the consultants that are needed to meet the legal standards that you want to impose here. They're going to have to evaluate, this lot, that lot, another lot somewhere else. And by the way, they'll have to evaluate the scenario where no parking is provided at all. So courts are then going to be in the process of deciding which is the appropriate baseline, right, for deciding whether option A is or is not safer than, is it option B or option C? And one could, I suppose there is no rule that says that if the church wanted to provide no parking whatsoever, that would violate some sort of duty, even though it could be less safe for them to provide no parking at all. Because then the parishioners are going all over into the neighborhood around Marconi Avenue, parking in the side streets. They're going to have to walk all over the area, right, and could get hit by a car. And that's because of what? The negligence now of the church for not having provided parking? And if they undertook that study, and that's what the study said, which was that doing nothing is actually the least safe option, then they have to provide parking? Where does this analysis take us?
I think it all boils down to the fact that if the church undertakes to establish a parking lot, it simply has to exercise ordinary care in making that decision of where it's going.
Studying that issue, if the church discovers through a study that it is less safe to not provide parking, do they then have an obligation to provide parking under your test?
No, there's no obligation of the church. They're not required to provide parking, and we have never stated.
If they are required to choose option B, the plaza lot, over option A, the across the street lot, but they are not required to choose option C or option A over option C, which is doing nothing at all, when the study says that option C is less safe, I don't understand that logic. That doesn't follow even basic transitive property. Why would they be required to choose option B instead of A on the ground that B is safer, but not option A over option C, which is doing nothing, when A is safer than C?
Well, these are hypothetical situations, but we have actual facts in this case.
Does it not reveal to us that this is an area that cannot be governed by this kind of standard? Because the nature of the inquiry is so multifaceted and so not susceptible to a clear policy solution through tort, right, that the burden of avoiding accidents here is not intelligently foisted upon the church, because the church isn't in a position to make a good decision relative to the other people, namely the pedestrian and the drivers who should follow the law and avoid, hitting people.
Well, I would disagree about that, because I think the church is in a far better position. A business which is established in a particular place for many years and is, as in this case, fully aware of the danger that it has created by asking people or directing people to park in only one place, is in a far better position to weigh the relative danger.
So let me try
than
to
a
just
new invitee.
ask a version perhaps of Justice Liu's question in a slightly different way. In tort law, because we are concerned with social policy and costs and benefits, we have to be especially concerned about consequences. And so if we accept your theory, why should we not be concerned that this may have a perverse effect and lead some churches to simply say nothing about parking in a manner that might be more dangerous to their attendees?
I think if a church says nothing about parking, they allow those invitees to exercise their discretion in full to determine where they're going to park. I would much rather, and it is much more socially beneficial for a church not to direct parking than to direct parking to a place that they know is going to
So I
require a
understand your
dangerous
answer
street
better. So
parking.
you're saying, yes, that may happen, but I don't think that that is likely to be dangerous, or more dangerous at least, because then everybody's on their own and they'll exercise their own duty and they'll look after their own interests.
That is true.
Thank you.
So under your analysis, if they just posted a fellow in their own lot that said, sorry, lot's full, and that was it, there would be no liability, even if Mr. Vassilenko parked across the street and chose to cross in the middle of the block in the rain and the dark.
That is true, because at that point, they haven't directed him to do a particularly dangerous thing. They haven't influenced his actions, where if they leave him to park where he wants, he can
At what
pick
point
out a
does
safe place to
Mr.
park.
Vassilenko have an obligation to conduct his own affairs in a prudent way? They didn't
I
say
think
you
he
can't
did.
come to church unless you park in the swimming lot, did they?
No, but I don't think that that is a determinative factor in the analysis. He was attempting to attend their function. He shows up. He's on their premises, at the main premises. They
if
give
the-
him instructions.
if
He
the-
follows the instructions.
If the guard said, lots full, can't park here, there are a number of other lots around, and Mr. Vassilenko picked this one and then walked across the street in the middle of the block in the dark, in the rain, the church wouldn't be liable in your analysis?
That's true.
What does the record show about precisely what Mr. Vassilenko was told?
They told him, you need to park at the pool lot. You need to follow directions. Here is the map. The map has an arrow from where Mr. Vassilenko is
Are you
to the
referring to
pool lot.
Exhibit 4?
I forget the name of the number, but it's the map that's reproduced in
Is
the
a
briefs.
map with arrows,
Yes,
and it has church parking,
yes,
pool parking,
yes,
and Walnut and Marconi Business Plaza parking.
correct.
And are you saying that the church is directing its parishioners to use the pool parking only if there's an overflow?
That's exactly what happened in this case, yes.
Is that what they directed him to? Because the map shows
Yes.
parking both in the pool parking and the Marconi Business Plaza.
Right, but they told him, you need to park at the pool lot. They used that specific words, pool lot. And they also told that to Mr. Skakoff, who arrived at the lot around the same time as Mr. Vassilenko. So it's not just one person. Mr. Skakoff was almost also injured in this same situation. He and his girlfriend arrived at the main lot at about the same time as Mr. Vassilenko. They were also told specifically to park at the pool lot. They arrived in the pool lot with Mr. Vassilenko at about the same time. All three were crossing back on Marconi at about the same time. They all see this car coming at them at 55 miles an hour. Two of them were able to evade the car. Mr. Vassilenko was not.
Those on the map, they said, be careful crossing the street. Would that have made a difference?
Possibly. They would have at least, there would have been a warning there. Although I think they would have had to have said,
The
be
average-
careful crossing mid-block because it is particularly dangerous. Crossing any street is a risky activity. You can get hit on any street. Some are more dangerous than others, and the church knew that Marconi was one of those.
So
You
the
have-
average adult Californian crossing in the dark, seeing a car coming at them at 55 miles an hour, needs a printed warning on a map to
He
put
did
them
not-
on notice that perhaps this isn't a good idea?
He did not see the car coming at him at 55 miles an hour, and he didn't walk in front of the car when he saw the car coming. The church knew that the speed of the cars,
I was only following up on what I understood you
fine.
to say. Did you say that the car was coming at 55 miles an hour?
that's what the record shows, yes.
Very well.
But what I'm saying is he did not see this car approaching until 20 feet before that car hit him, so he had no time to react to this car. It's not as if he saw the car and carelessly walked in front of a speeding automobile. All three of those pedestrians were very diligent. Mr. Skakoff testified to the fact that they were very diligent in looking for oncoming cars. They had to wait a while for the traffic to come from one direction to stop. They got as far as the center lane. Now they're in the center lane of a 5-lane thoroughfare. There are cars going by them in both directions in 2 lanes, and they are completely exposed in the center lane. and this was common. In this case, it was they had to wait in the center lane for a minute. In other cases, pedestrians had to wait in that center lane for up to 2 minutes. This is not a typical street crossing. And after they had sat in this center lane, completely exposed for a full minute, they then, believing it was safe after diligently looking both directions, tried to make that last leg of the crossing. And all of a sudden, this car comes flying out of nowhere and hit Mr. Vassilenko. So I don't think,
Which way was the nearest crosswalk?
excuse me?